Hi, my name is Gurjit Pandher. I'm a senior attorney here at the Nieves Law Firm. I'm here to talk to you about ammunition and firearm restriction laws in California. Prohibitions against the possession of the firearms or ammunition, generally speaking, is based on your previous criminal history or your previous history with the legal system. For example, if you are a convicted felon, if you're deemed a narcotic addict, if you have 2 or more convictions of brandishing a weapon, if you have been convicted of certain misdemeanors, even like a domestic violence offense, if you have been deemed to be suffered from a mental illness and the court has made that finding and determined that you should not possess a firearm, or if you're under 18 years old, it is illegal for you to possess the firearm and or ammunition. With ammunition, it goes even further. There's certain types of ammunition that you are unable to possess, such as armor-piercing ammunition or ammunition that has an explosive agent. Now, ammunition possessions generally are a wobbler offense. They can be charged either as a misdemeanor or as a felony. If it's a misdemeanor charge, and that's based on the discretion of the DA, unfortunately, but if it's a misdemeanor charge, it's up to a year in jail, and if it's a felony, it's up to 3 years in state prison. Now, it's also illegal to possess a firearm without a concealed weapons permit if you are not one of the individuals on that list. So you need to have that concealed weapon permit if you want to possess a firearm, 1, in a public place, 2, on a public street, or 3, in a motor vehicle. And those 3 different areas, it's illegal to possess that firearm. Now, generally, these are treated as misdemeanors with up to 1 year in county jail as a potential penalty, although there are aggravating offenses that makes it a wobbler. Now, as we know, a wobbler can be charged either as a felony or as a misdemeanor, depending on prosecutorial discretion. It becomes a wobbler if 1, you're not the registered owner of that firearm, and 2, you've been previously convicted of either a certain misdemeanor offense or a certain drug offense that is not on the list that we talked about earlier, like the domestic violence offenses. If you do get charged with a felony because of one of these aggravating factors, you can get up to 3 years in state prison. So we're not talking about a little bit of time here. The carrying a loaded firearm can be a straight felony if you have a prior felony or firearm conviction. If the firearm was stolen, it's registered as being stolen. The defendant, you belong to a criminal street gang as they deem and as they charge you as an enhancement, and the firearm was not lawfully possessed, and you're not legally allowed to have that firearm, for example, being a convicted felon. The felony, a straight felony, can be up to 3 years in prison. So once again, it's not a slight offense. It's something that the DAs in the state of California take very seriously. There is also what's called a 3-month mandatory if you have violated the possession of a firearm statute, plus you have been convicted of certain offenses like an assault with a deadly weapon, or shooting at an inhabited dwelling or car, or brandishing a weapon. You can get what's called a 3-month mandatory. So what that means is you have to do at least 3 months in jail or prison. Now, all of these statutes and all of this information I've told you has been complicated by the recent Supreme Court case, New York Rifle and Pistol Association Incorporated versus Bruin. The Supreme Court indicated that the Second Amendment allows people to possess these types of weapons. The case law is very new in this area. Please contact us. We can help you out. If you are charged with any sort of ammunition or firearms possession case, we have a lot of experience in that area and we can help you out. Thank you very much. Bye-bye.